We have Griselda Lewis, who's out in Palm Ridge for us, where serial rapist Nkosinathi Phakathi will be sentenced in the Johannesburg High Court, sitting in Palm Ridge this morning. So the judge, we understand, is already delivering that judgment. So let's take you live to those proceedings.
This is what was stated by the court in the matter of State versus Hasbrook, 1969, Volume 1, SA 356, open brackets, capital E, close brackets. In considering the offender, due regard must be had inter alia to the following factors: the age and background of the offender, the level of education, attainment, and position in society, family circumstances, whether married or not, the question of dependence, motive in committing the offense, whether for personal gain or for reasons of avarice or being actuated by some moral or laudable objectives, whether the offender stood to gain by the offense, the question of the accused being a first offender, the effect of punishment on the offender, and more particularly if a sentence of imprisonment. If a sentence of imprisonment is imposed, the prospects of reformation and correction and becoming a useful member of society, the presence or absence of remorse or contrition, whether instead of imprisonment an alternative method of punishment would not be appropriate in the circumstances. A mere perspective understanding of the accused human frailties as affected by the circumstances surrounding the commission of the offense in question, and a balancing of those frailties against the evil of the offender's deeds, influence, or encouragement to another. This is what was stated by the court in the matter of Lindbergh and another, 1975, Volume 4, SA 533, open brackets, capital A, close brackets. A due weight must be given to the personal circumstances of the accused. As a general principle, equal punishment for equal offenses is to be imposed unless the personal characteristics of the respective accused make such differentiation necessary. The feelings and the requirements of the community, the protection of society against the accused and other potential offender must be considered, whilst considering the interest of society as a factor in determining sentence. The interest of society should not be overstressed to the detriment of the personal factors of the accused. An enlightened and just penal policy requires consideration of a broad range of sentencing options from which an appropriate option can be selected that best fits the unique circumstances of the case before court. As this is what was stated in the matter of Samuels versus the State, 2010, capital ZASCA at 113. By accommodating the victim and all their representatives during the sentencing process, the court will be better informed before sentencing about the after effects of the crime. The court will thus have at its disposal information pertaining to both the accused and victim, and in that way, hopefully, a more balanced approach of sentencing can be achieved. Absent evidence from the victim and or their families, the court will only have half of the information necessary to properly exercise its sentencing discretion. It is thus important that information pertaining not just to the objective gravity of the offense, but also the impact of the crime on the victim and or their family be placed before court. That in turn will contribute to the achievement of the right sense of balance, and in the ultimate analysis will enhance proportionality rather than harshness. This was stated by the Supreme Court of Appeal in the matter of State versus Machichi, 2011, Volume 1, SA 40 at paragraph 17. The conviction in this matter of the case before court relates to the rape of the complainants, which took place during the period June 2012 and March 2021 around the areas in Davidton and Benoni. The accused did unlawfully and intentionally penetrate the vaginas of the complainants in counts 2, 5, 8, 15, 18, 23, 25, 26, 31, 44, 47, 55, 58, 59, 64, 66, 69, 80, 82, 86, 87, 88, 89, 98, 99, 101, 105, 106, 110, 112, 113, 116, 118, 123, 127, 128, 129, 131, 132, 137, 138, 139, 141, 145, 149, 154, 155, 156, 161, 162, 163, 164, 165, 170, 173, 175, 177, 178, 179, 181, 183, 184, 185, 187, 192, 195, 196, and 200. He penetrated these complainants with his penis without their consent. Further, the accused did unlawfully and intentionally sexually penetrated the vagina of the complainants in counts 17, 38, 39, 43, 51, 52, 70, 76, 88, and 119 with his finger and penis without their consent. Further, he unlawfully and intentionally sexually penetrated the vaginas of the complainants. Count 75, 158, 167, and 88 with his fingers. The accused further unlawfully and intentionally compelled or caused 4 of the complainants, who are children, without their consent, to be present, or forced them to watch him while committing sexual offenses by raping other complainants. The accused further unlawfully and intentionally inspired the belief in other complainants that they will be sexually violated. The accused unlawfully and intentionally compelled the 4 male complainants, who are children, without their consent, to commit an act of sexual penetration with the other female complainants, who were also children, by instructing those male complainants to have sexual intercourse with the female complainants without their consent. The accused further unlawfully and intentionally deprived 42 complainants of their freedom of movement. He further unlawfully and intentionally assaulted 2 of the complainants. He also unlawfully and intentionally stole cell phones of 3 complainants and cash of 1 complainant. According to the pre-sentence report, the ages of the victims in this matter range from 9 years to 44 years. Most of the victims are female, with the exception of the complainants in counts 94 to 97, who are male minor children. The offenses were committed between 3:30 in the morning and 10 to 11 in the evening. The complainants in counts number 2, 8, 10, 17, 23, 25, 38, 39, 43, 44, 47, 51, 58, 52, 58, 59, 64, 67, 70, 72, 75, 76, 79, 80, 81, 82, 86, 101, 105, 110, 118, 136, and 173 were walking in the street. The Complainant in count 175 was working with her parents, who were tricked by the accused to allow him to work with them, and along the way he forcefully took this 14-year-old complainant to a shack. The complainants in count 12, 15, 18, 26, 55, 87, 88, 89, 106, 113, 116, 128, 129, 131, 132, 137, 138, 139, 140, 145, 149, 154, 155, 156, 158, 159, 161, 162, 163, 164, 165, 166, 167, 170, 175, 177, 178, 179, 184, 185, 187, 188, 192, 200 and 201 were accosted inside their houses. Some of them were on their way to school and were wearing school uniform. Some of the complainants were at their homes, still preparing themselves to go to school. The complainant in count 167 was still sleeping when the accused knocked at the door of her parental place, and he opened for the accused. Other complainants were on their way to work. Some of the complainants were sexually violated at their homes in the presence of their family members, while others were lured into a secluded area or to other houses. Some of the victims allowed the accused into their homes after he falsely pretended to be either a gardener or had to fix water pipes or convey message regarding municipality documents that had to be completed in order to access certain services from municipality. Example, food parcels. The complainants in count 51, 52, 90, 99, and 90 and 99 were accosted at the railway line. Section 51, subsection 1, read with Part 1 and Schedule 2 of the Criminal Law Amendment Act 105 of 1997 prescribed the imposition of life imprisonment. Section 51, subsection 2B, Roman figure 1, read with Part 3 of Schedule 2 of the Criminal Law Amendment Act 105 of 1997 prescribed the imposition of minimum sentence of 10 years. The following evidence was led by the defense, Advocate Khokani, on behalf of Mr. Phakathi, led the evidence of Dr. Lynette Aru, who testified as follows: that she's a clinical psychologist who assessed the accused, and her report was accepted by this court as Exhibit E. The accused, at the time of the assessment, he was 39-year-old. He is the seventh of 8 siblings. He has a close relationship with his siblings. His mother is a domestic worker who worked very hard to provide the best possible life and opportunities for him and his sibling. The accused felt discriminated when he was informed that he is having a different father from other siblings. His mother refused to discuss the question of the whereabouts of his father with him. He obtained matric with good results. In 2005, he began volunteering at South African Police Service, where he worked for some months.
Thank you.
He resigned.
Right, that is where we will have to leave it, and not leaving it for good, but the magistrate there, obviously the judge going through all of the charges and of course handing down judgment in that serial rapist case, and this is of course taking place in the Gauteng High Court sitting in Palmbridge. Griselda Lewis of course watching those proceedings for us as well.